Okay, I want to welcome everyone to another Age-Wise webinar. Today, we're going to learn about the new legacy giving bill and a little bit of a reminder about the kinds of documents you need for the end of life. And a couple of things, if you would all be sure and mute yourself, we prefer you turn off your cameras because we are recording this and it just helps with what we do with editing. And with that, I will introduce Carolyn Wiley. Carolyn is an attorney at the Harris Law Firm. She focuses her practice on matters that are involving estate planning, prenuptial agreements for any of you older adults that are in that place to be getting married, and marital agreements and family law. She's been practicing for over 20 years. And what is really wonderful is that Carolyn is the co-chair of the Statutory Revisions Committee for the CBA Trusts and Estates section, and I'll let her explain what that is. But they do advise legislators about new legislation and changes that might be needed in the law. And with that, Carolyn, I'll turn off my mic and my camera and turn it over to you. I would suggest 1 second that if anyone has questions, we're going to hold them off until the end of this new legacy giving bill discussion, and you can put them in the chat as we go. With that, Carolyn, the screen is yours.
Well, thank you very much, Barbara, and thank you to all of the age-wise participants today. I'm really happy to be here to talk about this piece of legislation that is very exciting for those of us who do this kind of work, and I'm happy to talk all about it today. So, yes, Barbara had talked to you about me being part of the Statutory Revisions Committee, which is a long way of saying that what the Trust and Estates Bar does is we review the legislation that comes across our desk that we think could actually have something to do with the way we write wills or the way we advise clients to deal with their trusts and that kind of thing. And so all of the sections of the Bar Association do this, and we have a lobbyist, but it's not the kind of traditional lobbyist that you might think that we're getting involved in politics. We are really just trying to make one statute mesh well with another statute and call to the attention of legislators any problems that we see. And that's what we did when we worked on this legislation. We actually worked with the lobbyists from the Banking Association, the lobbyists from the Creditors Association, and the Colorado Nonprofit Association to make all this make sense. And so I'm not going to dive into the bill quite yet. I want to talk to you first about all the stuff we will talk about today. So here we go. If I can make my screen move forward. Okay. Here we go. So today we're going to talk about this new legacy giving bill and what it means for both nonprofits and for donors. And first, let's talk about what is legacy giving. Then we'll get into what donors themselves need to know and how to make legacy gifts to nonprofits. Then we'll talk about this bill that came across our desks in about November, and we had ready to go when the president of the Senate of Colorado asked us to make it ready. And then finally, we will talk about what nonprofits need to know, because this is actually going to affect them just as much as it's going to affect donors. So let's get started. So legacy giving is, in this context, when we are giving to charities. And it's a way to plan for your future and leave a legacy to the people that have meant a lot to you in your life who do good work in the world. And so only in this presentation, when I talk about a legacy gift, I will be talking just about a gift to a charitable organization. And there's two ways to make these kinds of gifts. The first would be that you can make these gifts during your lifetime. And the second would be obviously upon your death. And that's really what the bill has to do with. But let's talk first about lifetime legacy gifts. Anytime you want, you can make a legacy gift to any charitable organization that you want. And no one will question this gift unless you fail to support someone you legally must support, or somebody suspects you're being unduly influenced, or you do not have the capacity to make these gifts. So perhaps dementia or something like that is affecting you. And I would suggest to you that if you want to make gifts during your lifetime, that's a good idea for if your family does not agree with the legacy and the charity that you want to support. Just do it during your lifetime so that there's not a will contest after you pass away. And I wanted to show you in particular how AgeWise Colorado gives us a clue that they're a safe organization to give to. But first, let's back up and let me tell you a little personal story. As my grandmother was aging, she was often sort of bombarded in the mail with requests for charitable donations. And most of the time, these were very wonderful charities. And she would get out her checkbook once a week and she would write a $15 check to the American Cancer Society or the Humane Society, as you might expect. But once in a while, we would see a fraudulent charity, and it might say the American Cancer Association or something like that. Well, we knew that this was fraudulent if we were in the room, and we would say, oh, no, wait, Grandma, don't write that check, right? But by this time, her eyesight was failing a little bit. And so though she had full capacity, she may not have been able to see American Cancer Society or something like that. So this was the kind of thing that we were trying to help her with. And then eventually she did fall prey to dementia. And it was still nice for her to write these checks, but we would have to watch over it a little bit. But we didn't want to disrupt her routine. And so, of course, we would watch that the checks went to an appropriate place and that they were for an appropriate amount and that kind of thing. But I think it's important to note that AgeWise Colorado and other accredited charities will tell you that they are with the Better Business Bureau's accredited charity organization. So look for this kind of clue when you are thinking about what charities to give to. Of course, most people have the best of intentions. And I think as we age, we tend to become sort of kinder and softer. But we do need help sometimes looking for the clues as to what's appropriate to give to. And now in my grandmother's situation, we were dealing with mail, but now we're also dealing with messages on our cell phones and our email, and it gets to be a lot of bombardment from different places on top of the mail. So it's tough. So during your lifetime, as I said, you can make any gift to anyone you feel like giving to, any charity you feel like giving to, but look for clues that it's a safe charity to give to. And in death, you can also make all kinds of gifts, which sometimes are a great sort of tax write-off, but you can make gifts through deeds. You can give your car if you have the title to your car. And then you can make gifts in your last will and testament or in trusts, such as, I want to give 10% of my estate to XYZ charity, let's say Age-Wise Colorado charitable organization, and the remainder of my estate should go to my children equally. There's always that same risk that, one of the kids comes forward and says, Dad had dementia and he was being unduly influenced by the executive director of that organization, which gets sorted if it needs to be sorted after death. But it also gets sorted in just, if you do a good job of drafting your will when you still have capacity, it gets sorted there too, because we're going to give clues to the children that, oh, in fact, Dad had really considered that issue. So we think about death often as just being in our will, but actually what this bill was designed to do is to allow you to make a legacy gift not through your will, but through payable on death designations. So this might be from your annuities or your insurance policies. It could be from a savings or checking account. Often it's from securities registered in beneficiary form. And then sometimes it's also from your pension, your profit sharing, your retirement, or your employment related benefits accounts, benefits plans. So what I need to be clear about is the bill that I'm talking about, this brand new bill that just passed through the legislature, it does not cover gifts from your will or your trust. It covers gifts from payable on death designations. And that is important so that there's other ways to do this without having to do it only through your will. So let's now turn to what donors need to know in order to make legacy gifts to nonprofits. So the first thing, if you were making a gift that would comport with this bill, the first thing you would need to know is to go over to your bank or your credit union, your insurance company, or your brokerage account, your retirement account. Talk to the people that manage those. So the retirement plan administrator, the financial planner, those people, and ask them for the payable on death designation. Once in a while, it's called the transfer on death paperwork. But either way, that's the kind of paperwork that you're looking for. First, you have to consider your spouse and other people that are dependent upon you, because what's part of this bill is that you're not going to be able to cut out people dependent upon you when you make these gifts. But then you're going to want to go to this charity that you want to give to and obtain their full legal name and their address, telephone number, and website. Then you want to find out what their EIN number is and the relevant information that proves that they're a 501c3 or other charitable organization, and get their IRS determination letter, because this is going to be what on the other side of death is needed by the charity. It's important to talk to your CPA or tax planner because there are certain times that a will would be a better choice for certain tax issues than doing a payable on death designation. Please tell the charitable organization that you are making this gift, and then consider informing your relatives and your trustee that you are making these gifts outside of your will and outside of your trust, because you want to avoid surprises. You want to avoid your child saying, no, 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 Dad never meant to do that. But one thing I think many people already know is that you can save a lot of money by making charitable gifts, because it'll be a reduction in your taxable income. Gifting from certain accounts to charitable organizations can be tax-free, up to quite a bit of money. I think in 2026, it's $111,000. And don't forget that a charitable organization, a 501(c)(3), does not pay taxes. So that's very helpful because your money is not causing you, it's reducing your income tax, and it's also going to a charity, and they're not going to pay tax on it either. So it's sort of a win-win scenario. Then there's the traditional way to make the gifts to charity, and that would be to talk to an attorney and design a will or a trust. What we do often when we are considering talking to our clients about, okay, here's what we suggest in these charitable donations, is we want to explain the connection that our client has to this charity. So it's not a shock to the family when there's a considerable gift or a kind gift made to a charity. We don't have to do that if you volunteered your whole life at the Humane Society or the food bank, for example. That's just not necessary because your family will know that you've done that. The other thing that we are going to almost always recommend to you as your attorney, if you hire us, would be to set forth a percentage to the charity rather than a set dollar amount. And the reason is this: you don't quite know how long you'll live. And so if you set forth in your will, I want to give $10,000 to XYZ charity, and the only thing left is $10,000 upon your death, XYZ charity will get the $10,000, and your children, your spouse, whoever else will not get a dime, usually. Now, there's exceptions to this rule, but just know that we have to be careful of doing a set dollar figure, and we recommend a percentage. It can even be a percentage of a percentage, 1/2 of 1%. But just know that that's the kind of thing that you would likely be recommended to do. Okay, so those are the two ways you would give to a charity in general upon your death. Now let's shift gears and talk about this new bill. And it's an interesting bill. What it does, let's first just tell you the name of it. It's called Legacy Giving to Charitable Organizations, Senate Bill 26-118. We expect that the governor will sign it, and it will take effect 90 days after the General Assembly adjourns this year. So that should be about August 12th of 2026. The impetus for this bill is kind of interesting. What happened was that the entities holding the money would require the executive director of the charitable organization to establish an account with them to get the money out. Or maybe they would require the executive director of the charitable organization's social security number or their driver's license or their personal financial information. And so the nonprofit association came to the legislators and it said, this seems like a problem to us. Okay, so what we did was we helped the legislators and the Colorado Nonprofit Association draft a bill that would not require personal financial information to be given to the charitable organizations from the executive director or the person trying to collect the money. And it would also not require personal social security information to be delivered to these entities that hold the money. And everybody who did this, who worked on this bill, had the best of intentions. The Colorado Nonprofit Association identified a problem because, as you can imagine, these larger nonprofits have to go collect a lot of money for a lot of people. If you would imagine the University of Denver, every time they get an alumni gift, they would have to go find the gift, and they would have to try to get the money and it was hard to wait and wait and wait for the organization, the holder of the money, to release the funds. And it was hard to also have to provide personal information every time they were just trying to collect a charitable gift. So with that in mind, the Bar Association, the Bankers Association, the Creditors Association, and the Nonprofit Association worked together with the bill sponsors, and they're listed here on the screen. It was the president of the Colorado Senate, Coleman. We worked also closely with Representative Clifford and these other sponsors of the bill to come up with something that made sense. It now is designed to help charitable organizations, should be helping donors quite a bit, and help creditors, which include the family of the donor. And we'll get into that. Now, what charities need to know is that they can benefit from legacy giving within just 60 days if they present both an affidavit and they sign a waiver to the organization who's holding the money. This is a very different structure than the traditional structure, and I'll get into that, but I don't want to bore you with too much legalese, as we call it. So when the charitable organization goes to the entity that's holding the money, they will bring an affidavit, and it will say the donor has died, here's their name and address, here's a copy of the death certificate. It will describe the benefits that they think the entity holding the money has that's holding the money. They will give their full information as the charitable organization. And this is going to include their IRS determination letter and their W-9. It's going to include how to remit payment to the organization. And it's, of course, as an affidavit, it's going to say, I swear that the information herein is true and correct. It will have the signature of the appropriate representative of the charitable organization, and it will also be presented with, so the charity itself is going to be presented with a waiver from the person who's holding the money. And this waiver is going to ask the charitable organization to acknowledge that sometimes these gifts are subject to claims from creditors and claims from the family if the estate doesn't have enough money to satisfy those. And especially a spouse has very significant rights to claim the money. The creditors and everyone who's owed money by the estate, even if it's not a gift made by a will or a trust, even if it's a gift made as a payable on death designation, these creditors, like the spouse and the family, have the right to reclaim all of these gifts as needed to pay the appropriate allowances by law. And they have that right in a certain time frame to do that. And then the holder of the money, so the bank, Fidelity, those people, those organizations have to take the action needed to give the money to the charity or to hold it back within 120 days if they know of a claim. So the next thing to remember is that this will help donors too, because it will provide that peace of mind that we all worry about. It would ensure that legacy gifts are honored quickly so that the charitable organization can make a plan for not just how the money is used, but also to acknowledge the gift or to keep the gift anonymous if that's what the donor wanted. And the thing that I'm seeing the most is that, that I expect to see the most, because this isn't law yet, is that the family is going to see action sooner. And that's comforting to a family that is grieving the loss of their matriarch, their patriarch. This bill should help creditors, because we know that the families and the spouses still do have the right to recapture those allowances as they always have. And it's set forth some very specific timelines for the charitable organization because they are getting their money close to first, not necessarily first, but very close to first. And so if they would get the money within 60 days, they also have to repay the money within 60 days if they got it before the allowances were paid out. So they'll get notice from the personal representative, used to be called the executor, that there will be a requirement that they repay partial amounts or the whole amount of the money because someone has priority over them. If they can't repay the money, they'll have to pay interest. And also, just know that the court can get involved and take the appropriate action, such as, awarding interest to the family. They can issue an injunction against the charity from spending the money if the charity won't repay. And they can award attorney's fees and all the traditional court action that you would expect that a court could take. Now let's talk about the way that a donor could give and what my firm in particular considers when we are looking to design an estate plan with our clients. So we think of an estate plan traditionally as what we do with our clients as 3 documents for death and 3 documents for life. And so upon death, we will always work with the client while they're still alive to create the will, a personal property memo, which is exactly what it sounds like. If I can touch this thing, grandfather's watch, I may want it to go to a charity or I may want it to go to my oldest grandson. If we think about these gifts, we also talk about burial or cremation instructions and celebration of life instructions. And in those instructions, we often see a family say, in lieu of flowers, please donate to this hospice organization. And then we have these 3 life documents, and those are equally as important, if not more important, because they affect us while we're living. If we have incapacity, somehow we've gotten hit on the head, or we have dementia, or we just had dental surgery and we can't even pick up our prescriptions, we would have someone acting as agent with general power of attorney, or sometimes it's called financial power of attorney. We'd have someone acting as agent with medical power of attorney. And then we'd have this 3rd life document called a living will or an advance directive, which is somewhat irrelevant to what we're doing right now. But I just want to point out that of all 6 of those 3 life documents and 3 death documents, 4 of them allow gifts to charities. So your will, your personal property memo, your celebration of life instructions, and your general durable power of attorney would all allow the agent or the personal representative, whoever is making those decisions, to give gifts to charity. And then I didn't mention, because it's both a life and a death document, that there are ways to get into very specific giving through trusts. Trusts are a way to manage your money while you're still living, when you become incapacitated, if you ever do, and then also upon your death, and it's a very streamlined process. But while we don't get usually directly involved in a lot of these payable on death designations, we do always ask you to talk to your financial planner and your tax planner at the same time as you're putting together your estate plan with our firm, because we want to have you double check the beneficiaries of your IRA or your 401k and your brokerage accounts, because those are yet another way, as we've previously discussed, for you to continue to make charitable gifts, and a very streamlined way to do that. With that, I want to thank you. Thank you to Barbara and AgeWise for letting me present to you. Please feel free to reach out to me directly. I am very happy to provide a free initial consultation if you are interested in doing your estate plan with my firm. And just mention that we did this webinar when you call us. And thank you very much.
Carolyn, I have a question for you.
Of course.
You know, anyone that makes a donation, or at least this is our policy at AgeWise, you know, can designate what they want it to be used for.
Yes.
Since we're all volunteer, you know, it goes to operating expenses basically to keep the program going.
Yes.
But I'm wondering if you're doing this either way. I'm not sure about a will, but with this new legacy giving and upon my death, can you designate that? Well, you know, it's probably not a lot. I guess a very rich person, let me put it that way, might say, I want you to take this $1 million and build a building or something.
Yes.
Can you do that with any amount? I'm leaving $1,000 and I'd like it to go to XYZ.
You can. And that's why we like for the people that are making these gifts to talk specifically to the charities in advance, because the charity may say, hey, thanks for this $20,000. Yes, we'll use it to feed the animals at the Humane Society, but also we're getting really crowded, or we have a lot of leaking in this roof over here, so that the donor can say, okay, I only want my money to go to food, or the donor can say, great, let's put a new roof on over there, you know. So
Okay.
to me, it's really important that we are speaking with these charities and making sure that our legacy makes sense. So, you know, to me, I think everybody should have an open line of communication. If we're doing it in a will, we're saying what the donor's intentions were. If we're doing it in a, you know, trust, same thing. And I would say that if there's a specific fund that the donor on a payable on death could give to, they can fill that out in the bank's paperwork or the, you know, Fidelity paperwork, to my knowledge. If not, just talk to the charity directly and say, hey, when you get this legacy gift, please do use it to only feed the children or put a new roof on the, you know, the building. So,
Right. My other question is, if you are doing this designation from an annuity or a brokerage account or any of those vehicles, can you do a percentage there?
I
That
believe
I
so.
want my
Yes.
50% of my life insurance policy to go. Okay.
Yes, because you can name more than one primary beneficiary. So primary beneficiary number one would be spouse, primary beneficiary number two would be charitable organization, contingent if spouse isn't living children, or contingent if charity is out of business, some other charity.
Right.
So I don't see it being an issue, but I will say I have run into questions that the plan administrator has had, and then it's important to talk to the plan administrator and sort it out, because it can be only, it's almost like writing a tweet. It can only be a certain number of characters long. And so sometimes you'd want to double check that with the plan administrator.
You know, I just thought of something else. This sounds like it's made for people with a substantial estate. And if maybe I am a person without a substantial estate,
Mhm.
and I wanted to, can this be used by the average person that maybe only wants to leave a couple $1,000s or
Yes.
$500.
Yes, absolutely. Yes, it absolutely can. And that was something, even though the Colorado Nonprofit Association came to us sort of driven by these larger foundations like DU, for example, the University of Denver, it is something that the smaller nonprofits who are members of the Nonprofit Association looked at and gave feedback on as well. And in my experience, that was the way I was approaching it as, oh my goodness, these little charities can't be, and I say little, these little charities can't be, having to go and open from one person opening 5 different bank accounts just to receive the money. And also the donors want to be able to give this money and have it have a lasting legacy. But they can't, what if they only have $1,000 to give? Or, I mean, only, that's a significant gift, right? And so we looked at it from all of these perspectives. And at least on the lawyer's side, we were definitely looking at it from the perspective of not wanting to alienate a donor who has a smaller estate. And so we definitely made it so that whoever gave would have the same rules apply. And so,
Okay.
yes, always know that no matter the size of your estate, you can give these gifts. And it could save
I,
a lot of taxes for you.
yeah, yeah, I always like that tax benefit. I don't see anything in the chat. Does anyone else have a question?
And I've put my contact information from my website in the chat. If anybody wants to copy it down, feel free.
And I would also remind everyone you're on the AgeWise website and you're one of our patron sponsors. Thank you very much.
Thank you.
And I guess I'd have to again say AgeWise is a 501c3. We do accept gifts of any amount. It's amazing. $5 can help sometimes as much as 500.
Yes.
Well, I guess with that, we will say thank you. Thank you to all of our people who attended. We will be posting this on our website probably within a week. I have a question here. Will the slides be made available?
I'm happy to give those straight to you, Barbara, and make
Okay.
those available, and we will put them on our website as well.
Okay, and I can send them out. And again, you can also review the recording as soon as we get it up. We just clean up any editing glitches as we go. So I wish you all a very pleasant day. And thank you so much, Carolyn, for sharing this information. I don't know how all of us would know about it otherwise.
And, I'm just assuming the governor's going to sign it, but I have no information that he wouldn't sign it. So,
Okay.
well, thanks,
Well, thank
everyone.
you.
Thank you, Barbara. I
Okay.
appreciate the time today.
Have a great day, everyone.